Hello! If you're watching this video, that probably means you're a student at SMU School of Law starting this fall. This series of videos is designed to provide you with a tool that will be helpful in preparing for class and also for understanding the law more generally. So welcome to SMU. Here's a picture of me because I bet you'd like to know what the person whose voice you're hearing looks like. I am a professor at the law school. I teach civil procedure and other related subjects. If you are an evening student this fall, I'll actually be your civil procedure teacher. But let me also welcome you on behalf of the law school community more generally, and especially my colleagues on the faculty. We're very excited that you're joining us this fall and look forward to having you in class. This is a series of 3 related videos that will walk you through the steps of reading and understanding cases and taking notes on those cases in a way that will help you both immediately in class and later on as you prepare for finals. We're going to talk about the fact that briefing is really about legal analysis as the point. The main point is not merely writing something down. We'll talk about the components of a case brief, and then in videos 2 and 3 we'll try it out. I'll talk about the components in more detail, and as we do each component, we'll give you a chance to try your hand at writing that down and understanding it in that way in the Kiefer case, and then comparing it to some samples that I'll give you. So when we get to videos 2 and 3, be sure you have available the Kiefer case itself and also the blank orientation briefing form. So reading cases is about learning the law, and that's what we're going to talk about. If you've taken a look inside your case books that you have bought for your first semester, you'll see that they're called case books for a reason. They are full of cases. And reading cases is the main way that you will be learning the law during your first year. Why cases and not lists of rules? Probably your friends not going to law school imagine that you'll be memorizing long lists of rules and reciting them back as if it were an undergraduate course or a high school course, but that's not what you do. Cases are read and are the main body of the law, often because even when the law is written down as a rule, like a statute or a regulation, it's often not as clear as someone might think. For example, take something really straightforward like a statute that says no vehicles permitted in this park. Somebody wants to ride a tricycle. Somebody wants to put up a statue that looks like a World War I Jeep. Are those vehicles? What makes something a vehicle? So you'll have cases deciding and interpreting, and those are very important, and we need to learn how to read and understand them. More fundamentally, the common law itself is composed of series of cases that interpret the law and also that are the law. One case becomes precedent for later cases. A later case will follow the rule and decide whether similar facts make a difference, don't make a difference. Looking at series of cases help flesh out what the law is, and so that's what we study, and that's what you will become increasingly skillful at interpreting and applying. So we read cases and we brief those cases in order to learn the law. One of the things that we'll learn to do is extract general principles from the cases. They'll be embedded in them. More importantly, perhaps, to understand and analyze those principles and the reasons behind them, because that will help you figure out how those principles would apply to a different set of facts. And that's what you'll be doing for clients when you're in practice, and that's what you'll be doing on exams when you're in law school. In order to be able to do that successfully, you have to read the case carefully. You have to think about it, pull it apart and really grapple with it, and think about how you might extrapolate from what's there to new situations. For example, suppose you read a case in your contracts class involving a sophisticated consumer and a company. They enter into a contract, and the consumer later is unhappy with some of the terms of that contract, doesn't want to have to comply with them, but the court says, no, you signed a contract. That was a meeting of the minds, and it's an important part of freedom of contract that people are bound by the agreements that they make. Second case, not a sophisticated consumer. In fact, a consumer who can't read or write and whose first language is not English. Would you apply the same rule to that consumer? Is it the same principle of freedom of contract, or is there an important difference between the sophisticated consumer and the illiterate consumer who may or may not have understood the language, even if he or she had been able to read? That's what we're talking about when we say applying a principle to a different set of facts. Making the case brief, doing the legal analysis is going to help you answer that kind of question. You may be saying to yourself, yeah, fine, okay, but do I really have to brief it? I hear from the 2 and 3 L's that you can just book brief. You can just make notes in the margins, and that works just as well. Well, my recommendation to you is that you do not listen to them. Making the brief is what forces you to actually think about it. And the point of the brief is not holding on to the brief or owning the brief. The point of the brief is making it, going through that thought process. And scribbling notes in the margins will not make you do that in the same way. So especially when you're just starting out, make the brief. Also, putting it in writing not only makes you put it into your own words, which is going to help you understand it and internalize it, it gives you something you can bring to class that you understand. And so if you get called on and you suddenly freeze up in nervousness, this is a great security blanket. Look down at your friendly brief and think, oh, yeah, right, I remember this case, and you'll be able to answer the questions and feel much better about it. In addition, making the brief is an example of put in more time now to save you time later. If you have a good brief where you have written these things down, like the rules and the issues and the principles and the arguments, you will be miles ahead when you start making an outline and study for exams at a time when you're frankly going to be even busier than you are now. So more work now, less work later. Go ahead, make that brief no matter what the 2 L's tell you. Parts 2 and 3 are going to go into more detail about the components of the brief, but right now I do want to just talk briefly about how you read a case to prepare to brief it and what those parts of the brief are. So before you can brief the case, you've got to read it. And reading a case for the purpose of understanding it is a lot of work, I know, but it's worth it if you want to understand. A case is not a short story. So instead of reading through to the end to find out the surprise ending, oh, that's how they came out, instead, skim through it first. Just identify what the issues are and see who wins. Which way does the judge come out on the issue or issues? That's the first time through. Quick. Second time, read it carefully. And now you know how it comes out. So what you're looking for are the judge's arguments that support that conclusion. What are the arguments? What are the reasons? Read it carefully. Only on the third time through do you actually make the brief. Reading it carefully, briefing as you go. That system will actually save you from writing down things that you really didn't have to write down, which is what happens if you try to write it down the second time through. And it will also help you make your brief be more concise, more organized, more helpful to you. So although again, more work to begin with, less work later. When you're in that third time through where you are actually making the brief as you read, you're creating it. Now don't worry and think that there's some perfect, correct form of a brief. Everybody does it a little bit differently. And you yourself might even do it differently for different subjects because different professors emphasize different parts. For example, there's a part called procedural history, and you will likely find that your civil procedure classes emphasize those because that's the process of the case, and we are all about process and civil procedure. Different people will even tweak the components. Some people will put in more detail, some people will put in less detail. It's about you and how you learn best. But if you include these components that we're going to talk about, that should assure that you are doing the necessary analysis, that you are going through the thought process that you need to be able to learn the law by reading the cases. So the first 3 components of a brief that we're going to talk about and that you're going to use are a kind of background information. There's what we call the caption, just information about the name of the case and where it came from. we're going to talk about, in the second section, the facts. What happened in the real world that led to this litigation? And one of the skills you're going to learn is how to limit that fact statement to the facts that actually affect the outcome, the facts that matter legally. And third, as I mentioned, the procedure teacher's heartthrob, the procedural history. That's the in-court facts. What happened in court to get the case to the opinion that you're reading? The next three components of the case brief are the heart of the legal analysis. First, identifying what is the issue, what is this case deciding, or there may be more than one issue. Generally, it's going to be stated as a question, and the question may vary in nature depending on the case. Sometimes it'll be looking to see how law that everybody agrees on applies to the facts. Other times it'll be a more abstract question of what the law should be. Should the court adopt a new rule? Should it change the rule? Should it keep the rule? Some people in the issue section find it more helpful to them, instead of stating an issue as a question, to identify the parties' competing arguments. So for example, they would say, plaintiff argues this, defendant argues that. And the difference between this and that is going to show you where the crunch is. Where's the undecided question? The next section of the case brief is the holding, and that's what tells you how the court decides the issue, or what rule the court adopts. Then the longest section, and the one that shows you understand not just what was the issue and how was it decided, but why. Perhaps the most important part. That may be a statement of what the abstract rule is. It may be a statement of policy. It may be about the impact of the law. It may be about analogies to other cases. But that's a really important part, both because it helps you understand the rule itself and because it'll help you figure out, once again, how that rule might apply in new situations that you haven't seen yet. We'll talk very briefly about some additional components that you'll find in some cases and not others, and therefore in some case briefs and not others. The most important would be a concurring or dissenting opinion. A concurring opinion agrees with the result, but for different reasons. A dissenting opinion disagrees. And usually if a casebook author has included those in your casebook, they did it for a reason. So don't just skip over those as if they were just taking up space. Usually it's there because they point to important differences in philosophy or competing arguments about how the case could have been decided that will be important in your class discussion, and may also give ideas about ways to apply the rule or arguments for changing the rule. Dicta is the word we use for stuff that the court puts in the opinion that isn't really necessary. It's not needed to decide the case before it. But dicta can be important either because it limits the holding, or it may give a clue about how the court would decide a different kind of case. Or sometimes today's dicta becomes tomorrow's law. If there are technical legal terms in the case that you don't understand, it's very important to look those up and go ahead and write them down in your case brief, because if you do that now, again, first, you'll actually understand it. That will be good. Second, if your professor asks you what that word means, you'll be able to tell them, and then you'll feel good about your performance in class, and you'll help your classmates. And third, when it comes time to make an outline, you've already looked up that legal term and you don't have to do it again. Another example of more time now, less time later. Okay, ready to give it a try? What you should do before you turn to part 2 is read the Kiefer case carefully, but don't brief it yet. So do those first two. Skim it, and then read it carefully to look for the reasons. Print out, so that you have it available, the orientation brief form, the unannotated one, so that you have space to write down the answers as we go through and play with it. And then you'll be ready to go to the next video, How to Brief a Case, Part 2. See you there.